Hi everyone, my name is Rachel Marks and I am the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Kyle Ubel, a Minnesota construction lien law guru. Today's webinar's topic is Don't Sign a Release Unless It Passes This Checklist. So without further ado, I'd like to introduce the fabulous Kyle Ubel.
Thank you so much. As was mentioned, my name is Kyle Ubel. I practice law here in Minneapolis, Minnesota at the law firm of Frederickson and Byron. Happy to take any questions at the end. Please submit them based on the instructions that you saw there at the beginning, and we'll try to take all the questions at the end. So without further ado, signing a release can be a big deal. It can be a big deal whether or not you're the person who a claim is being asserted against or the person asserting the claim. And so I guess topic number one is always, if you have a go-to attorney, always consult with your lawyer before you sign a release. And in connection with that conversation, I anticipate that you'll cover the following issues that we're going to walk through today. So the first thing that should be covered in connection with any release is that if there's going to be an exchange of money, a settlement amount, your release agreement, your settlement and release agreement should include a description of the timing of the payment of the settlement amount, as well as the form in which the payment's going to be made. Is it going to be made by check, cashier's check, certified funds, wire, etc.? These comments apply whether or not you're the person being sued. For example, maybe you're being sued because you're a general contractor and a subcontractor suing you for not paying them as a sub. Maybe you're a project owner and you're suing someone for a construction defect claim or the like, or you're a contractor suing a project owner for failure to pay. So there's all different ways that these kinds of release issues can come up. All of those kinds of disputes would, if they're going to be resolved voluntarily, not through the court system, they would involve some kind of a release, and frequently they would involve a payment of some negotiated amount of money. So you're always going to want to have the settlement amount, timing, and form of payment in the settlement and release document. If there's unfinished work or allegedly defective work, frequently what will happen in connection with obtaining or giving a release is that there will be a negotiated punch list or negotiated warranty work. Very, very important that you be very detailed, very specific about what work is going to be done in exchange for the release. This is in fairness to both sides and to prevent further disputes. You want to be very clear with one another about who's doing what, when, and where. Who will perform it? Will you, as the general contractor or the subcontractor, perform the work? Or is some third party going to perform the work? If you're going to perform the work, typically what we would do is we'd negotiate how it's going to be confirmed that the work was done and that it was done correctly. Again, that's important so that there's no more disputes in the future. And finally, you want to specify what the timing for that work is going to be. Is it going to take a month? Is it going to take 3 months, 6 months, etc.? You want to be clear in the document on the scope of the work, who will perform it, who will confirm that the work was done, and what the timing for that is. Next, if payment issues are implicated, particularly if it's a subcontractor or a prime general contractor asserting a claim against a project owner for non-payment, there are going to be mechanics liens that are implicated. There's probably already been liens filed perhaps, or if there's litigation already pending on a lien claim, there might be something called a notice of lis pendens. More on that in a minute. But with respect to mechanics liens, you want to make sure that your settlement and release agreement address at least these issues with respect to mechanics liens. First, an identification of what liens are outstanding on the real estate record. 2, how they will be handled. Typically, there's an agreement that the liens will be released upon payment, and what the timing of the release will be. If there's a lien, again, I'm repeating myself, but it's important. If there's a lien involved, it's probably because one of the contractors or material suppliers is asserting non-payment against somebody, and the timing of the lien release will be conditioned upon receipt of payment, whatever the negotiated payment is. So that typically would be the timing term for a release of the mechanics liens. Last thing I'll say on mechanics liens is if the intent of the agreement is that it's the negotiated full payment amount and the parties are going to be done with one another upon completion of all of the items in the settlement and release agreement, typically this would be a full and final lien waiver, not a partial. Next, if there is already pending litigation and the litigation is to be released or dismissed in connection with the settlement release agreement, and that would be very, very typical. I think it would be highly unusual for the dismissal not to be part of this agreement. There's a few items that need to be provided for in the agreement, mainly their process items. First, who will be responsible for filing the dismissal document with the court? Will one side's lawyer do that, or another side's lawyer, that kind of thing? Make sure that the agreement has as an exhibit to the agreement the actual document, the agreed upon document that will be filed with the court, and review that with litigation counsel to make sure that the language in the dismissal document satisfies all the conditions that are required under the local rules for whatever court you're in. And then earlier I mentioned the concept of a lis pendens. What a lis pendens is, it's sort of like a mechanics lien in concept, except instead of giving somebody notice in the real estate records that someone might have a mechanics lien, what a lis pendens does, it's a fancy legal word for the document that is filed against the real estate in the county recorder's office, giving notice to other parties who may have an interest or a potential interest in the real estate that there's a litigation, a pending litigation that could affect title to the real estate. The reason that would come up is because there's a mechanics lien claim, which of course could potentially affect title to the real estate if the lien is foreclosed upon. So that goes to say, in addition to providing for dismissal of a lawsuit, the agreement should provide for the timely release of the lis pendens so that in addition to the lien being released and no longer encumbering the real estate, the lis pendens will also be released and will no longer encumber the real estate. Again, typically that would be conditioned on payment of the negotiated settlement amount. Next, the meat of the matter is the release language itself. Here are 5 topics to cover on release language. First, typically the release will be mutual. I release you and you release me so that no one can sue one another when we're done with our negotiated settlement. So it should be a mutual release, not one-sided. That's typically the way it goes. It should release all types of claims. It should release contract claims. It should release tort claims like negligence. It should release any claims sounding in quantum meruit or unjust enrichment. Those are called equitable claims. That's what lawyers call them, equitable claims. So it should be a comprehensive claim, a comprehensive release of all claims available at law, in contract, or in equity. It should be a release of all known and unknown claims. The last thing you want is not for there to be a release of unknown claims. You think you just got done being sued or almost sued, and then the next month the same person comes back and said, well, I didn't know that you had done this, this, and this, and I didn't release that because I didn't know about it, and now I'm going to sue you for that. That would not be a great outcome. And so you want to make sure that if you're the person being released, that you're getting a release that expressly says it's a release of known and unknown claims. And if you are the person giving a release, which if you follow the first piece of advice, which is the release should be mutual, you're going to be giving a release of known and unknown claims. Think to yourself, probably in consultation with counsel, of what claims could be out there that I don't know about, and have a conversation with a lawyer like me or one of my colleagues up here in Minneapolis about what that might be. The release should be through the date, the effective date of the settlement agreement. So for all of time up to the date that the parties sign the settlement agreement, you're done with one another. If someone does something inappropriate or improper under the contract or under the law the next week, that would be a new claim. The reason for that is the law generally does not allow you to release future claims, and there's policy reasons for that, right? We don't want people to negotiate that they can't be liable for something and then do something improper in the future. So it would be a release of claims through the date of the agreement. And then I have here that I've got some sample language. So I'm just going to walk you through, I'm going to read through here a typical paragraph of what a release might sound like in a Minnesota settlement agreement. In exchange for the terms in the settlement agreement, on behalf of itself and this is the first thing to talk through, the release is given not on just your behalf as the construction company, it's given on behalf of all of your successors and affiliates and assigns. Those are fancy words for your company and all of the people associated with it. Somebody might also include owners in that, so you're being released as the owner of the company. Release and forever discharge the other party and their respective heirs, successors, affiliates, assigns, owners, etc. And you can build in whatever related parties are going to be released. They're being released from any and all claims, demands, actions, suits, proceedings, complaints, liabilities, charges, damages, judgments, costs, and expenses of every kind and nature. You can see that the long list that is intended to encapsulate any available claim, known and unknown, including claims for attorneys' fees and costs in law and in equity and in contract or tort, that one party had, claims to have, or may have against the other party, including but not limited to any claims that could have been asserted in relationship to the work performed by, and then you'd insert the name of the contractor. That's an example of the broad kind of language you'd expect to see in a release. Next, your settlement and release agreement will likely and should include what we call a no admission of liability claim. And that's a short provision in the agreement that will say by signing the agreement, you're not admitting that you're liable, you're simply trying to resolve a dispute. Next, and this is particularly important for construction industry members, contractors and subcontractors and material suppliers alike, the agreement should include some provision that, one, the agreement's going to be confidential, and two, that the parties agree not to disparage someone. These are called confidentiality and non-disparagement provisions. The reason for this is twofold, the reason that it's important. First, with respect to confidentiality. A lot of construction industry members make it a business practice not to litigate things to the death. Rather, they make a business practice of settling disputes. The reason is it's good for business. You'd rather spend your time, money, and energy building things and planning projects rather than litigating and paying people like me to litigate things to the death if you can avoid it. And second, you get a good reputation. You get a good reputation from resolving your disputes rather than litigating to the death. That's common. That's a common thing I hear from my clients. It's important that your settlement agreements remain confidential, however, so that other clients don't start learning about what tactics work or what negotiation habits might work against you in particular based on all of the things they've heard about the other settlements that you've arrived at with previous clients who raised issues or that you had issues with yourself. And so it's important that each settlement agreement, each negotiation process is an entity unto itself and that it won't somehow infect or color your future negotiation processes with different clients. And the way you can try to guard against that is by including confidentiality provisions in your settlement and release agreements. Non-disparagement provisions are primarily important because it prevents people from settling with you on day one. You think everything's resolved, and then the next day you go on Google Review or Better Business Bureau and you realize that they just disparaged you the next day because they weren't actually satisfied with the outcome. And so now you've got that hanging out there and there's not much you can do about it. If you put a non-disparagement provision in the agreement, there's a lower likelihood that they'll do it to begin with, and if they do it, you could try to address it with your lawyer by having them send a letter saying, hey, we saw that you did this the day after you signed the agreement, would you please take that down because it's a violation of the non-disparagement provision. Next, attorney's fees and costs. There should be a mutual waiver of attorney's fees and costs. You pay your fees, I pay my fees, no one's paying the other side's fees, with one important exclusion. If someone breaches the settlement agreement, for example, the client goes out and breaches the non-disparagement provision by putting a nasty review online the day after you thought you settled with them, if you have to enforce the settlement agreement and you win your claim that the settlement agreement was violated, then you can get your attorney's fees for prosecuting that claim. But other than that, everyone's paying their own attorney's fees. Finally, the agreement should have what we call an entire agreement clause, meaning if there were side deals or other discussions leading up to the settlement agreement and they weren't included in the written settlement agreement, those discussions do not apply. And this happens a lot, frankly, with project owners. You might be out on the project site and have a conversation with them, or you had a phone call the week before the settlement agreement was written down and signed, and they thought they heard you say something, and all of a sudden that comes out of the woodwork a week after the settlement agreement was signed. Frankly, that most often comes up on scope of work. So you sign a scope of work or a punch list in the written settlement agreement that has 10 items, and then the next week they say, well, I thought there was an 11th and a 12th item. We talked about that a month ago, didn't we? Well, maybe we did, but our agreement says that this was the entire agreement. We wrote this down, and anything else that we talked about on the side is not included. That's important to prevent against scope creep after the agreement is signed. That's all I got. I was going to try to keep it to 15 minutes so we have time for questions. So if anybody has questions, please do let me know, Rachel.
Okay, perfect. First of all, I just want to say thank you so much, Kyle, for your time today and educating us on this important topic. You provided us with super helpful and extremely valuable information. As for questions right now, I do not see any that have come through. However, if anyone here does think of a question after the webinar, please feel free to reach out to myself or Kyle, and we will make sure to answer any questions you may have. If you'll do me a favor, Kyle, and go to the next slide. Okay, if you guys would like to take a moment to review us on Google, we would greatly appreciate that. And if you go to the next slide, please. Okay, so let's talk about our next webinar with Kyle. The next webinar will be on Tuesday, November 7th from 3 to 3:20 p.m. That's Eastern Standard Time. The topic will be getting paid faster with liens, bonds, and contracts. So go ahead and register at sunraynotice.com/education. And if you'll go to the next slide. Okay, and that is all that we have for you today. So thank you for everyone who joined us today, and we hope to see you on our next webinar. Thanks so much.